Good morning, everyone. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, I'd like to dive right on in. The first thing we're going to talk about is H-1Bs. Yes, CAP season, the initial round of CAP season is officially over. All those individuals that were selected in the H-1B lottery back at the end of March, all of those H-1B applications must have been submitted to the Immigration Service by June 30th. So hopefully you got that in. And I just wanted to give out a really quick reminder. There's a lot of remote work happening and work from home and, work from anywhere and people going back into the office. If you are on an H-1B and when it was filed, if your work site has changed, so meaning if you moved from the office to work from home, if you moved from work from home back to the office, and those work sites were not reflected in your initial application, then you are probably due to amend that application. So just keep that in mind. We do need to tell the Immigration Service when we've had a significant work change, and a worksite change will sometimes trigger that. So just keep that in mind. But I had to mention H-1Bs because H-1B season. So moving on, also wanted to remind you all that CBP is now operating a stampless entry program, which means you no longer get an I-94 card when you enter that is stamped and that has the day that you are supposed to leave the U.S., okay? So it is crucial that every single time you enter the U.S., you want to go online to the CBP site and get your I-94 card. You can download it. It is a very user-friendly site. You need to give them a few pieces of information, your name, your date of birth, your passport number, all information that you have, all information that's in your passport. So make sure that you are doing that. And I tell people to do that for every single time they enter the U.S. CBP is probably never going to go back to the paper system, so you're not going to collect your I-94 cards, you're not going to make copies of them, so definitely go online and make sure that you are pulling those down. It is super important to know what is in that I-94 card because you are bound to it. If the officer makes a mistake in terms of the visa status, that the status that they enter you in, maybe they enter you as a visitor instead of an H-1B or an L. That means they have essentially taken away your work authorization on paper. So we need to get that fixed. Let's say they've only entered you for 2 days or 2 weeks. We want to be able to reach out to them and ask them why. Oftentimes that just winds up being human error. And the agency has been generally pretty great about fixing that for us. But they don't know that something is incorrect, and we don't know if something is incorrect if that I-94 card is not downloaded. So you want to make sure that you're making sure that you're downloading it every single time you enter the U.S. It is also really important to have because, one, it tells us what your work authorization status is, what your category is. It tells us the category, the visa category that you were entered into the United States. It is super important if you need to renew or get your initial driver's license. The DMV in your state wants to see that you are here in status. So a valid I-94 card is super important for that. We also want to show that my accountant friends love the I-94 card because it shows them how long you've actually been in the U.S. And so for accounting reasons, I'm not an accountant, so I will not go into those reasons, but they need to know how long you have been inside the U.S. for tax purposes, okay? And it is super important to know when you've been inside the United States, when you've been outside the United States, if you are applying for U.S. citizenship. There are physical presence requirements for U.S. citizenship applications. And one of the first places I go when I'm doing a citizenship application for my clients is to look at their travel history, which is also available on that same I-94 card website. Okay, so make sure that you are doing that. And if you see any issues, name misspellings, You're curious about the date. Maybe you thought you would get longer than you actually got, or maybe the status is incorrect. Make sure that you take steps to get that changed. If you're not quite sure how to do that, feel free to reach out to my office. We are happy to help with that. 954-903-1337. Next big thing I want to talk about this morning is premium processing for students. We have seen throughout this year that the Immigration Service has been expanding those applications that are eligible for premium processing. So premium processing, for those of you that may not know, is a program within the Immigration Service where they essentially expedite the processing of your application for an extra fee. The majority of premium processing takes place within 15 calendar days. For some more complex applications, it is 45 days. But that is certainly better than some of the current processing times that we are seeing coming out of the agency. So keep that in mind. But premium processing for students is now up and running. They did a slow phase in, so that we're completely phased in now. So if you have a application that is currently pending to change your status from one status, let's say visitor visa, to student status, and that is our Fs, our Ms, and our Js. So F1, F2, M1, M2, and J1 and J2. So principal and dependent. If you have an application that's already pending, or you are getting ready to submit an application to change your status to one of these student status, you can apply for it using premium processing. So that is great news for our students, where sometimes these applications were taking a very long time within the agency, and students had to keep going back to their educational institutions, letting them know, keeping them updated, and essentially pushing back the start time of their academic programs. So hopefully premium processing for students will eliminate having to push back their start dates. The big thing that we need to know about the premium processing with students is the premium processing clock does not begin until after the biometrics have been submitted to the agency. So that means when you get your biometrics notice, make sure that you go to your biometrics appointment and do your very best not to reschedule. Because if you reschedule, that just pushes back the time frame of your premium processing, okay? So premium processing clock does not begin until the agency has received your biometrics. That's a little bit of a curveball for the premium processing for students, but it is still going to be much quicker than our current processing times. So just keep that in mind. The next thing I want to talk to y'all about is the Florida Bill 1718. It went into effect this weekend, this past Saturday on July 1. This is a law that is only in place in Florida. So everything else I talk about is national, because immigration is a national issue. The rules come out of Congress and the White House and the various federal agencies. This time, I am talking about just a Florida bill. So it's a Florida Senate Bill 1718, went into effect this past Saturday, July 1. It has some very significant provisions in it that will impact employers and employees. So some of those provisions are: employers with 25 or more employees. Now, again, those are employers in Florida, must use E-Verify to check the employment eligibility of all of their new hires. So E-Verify is a government-owned system. It is owned by one of the immigration agencies, and it is a way for an employer to send in information about their employee, and that E-Verify system pings Social Security Administration and DHS, Department of Homeland Security. And so the employer is either told, yes, everything works out, this person is who they say they are, they have work authorization, or it may come back and say, we have a non-confirmation. So maybe the name doesn't match the social security number. Maybe the name is right, but maybe this person doesn't have work authorization. And so there is a pretty methodical process to looking into those non-confirmations. But Florida has said 25 or more employees. Now those employers must now be using the E-Verify system for all of their new hires. So if you need help with that, please let us know. We're happy to help you with that. Also, Florida Senate Bill 1718 also says that employers who are not in compliance with using E-Verify, they will be notified that they have 30 days to comply or face a $1,000 daily fine until they are found to be compliant. So a $1,000 daily fine if they are found to be non-compliant. So keep that in mind, my Florida employers. State agencies, so Florida state governmental agencies can end contracts with companies that are found to be out of compliance with Senate Bill 1718. So if you are a Florida state government contractor, this is something that you want to take very, very seriously. Again, 25 employees or more in the state of Florida, you must be using E-Verify as of this past Saturday, just as a couple of days ago. Florida Bill 1718 also invalidates driver's licenses that are issued to undocumented individuals by other states. So there are other states that issue driver's licenses to individuals that are here in the United States that are undocumented. The state of Florida will now no longer recognize those driver's licenses that have been issued in other states. So if you're an employer and you have any questions about E-Verify, feel free to give my office a call, 954-903-1337. As well, while this is not a part of Florida Senate Bill 1718, I think it deserves saying that E-Verify is different than I-9s. You do not get out of doing your I-9s just because you are now required to sign up for E-Verify. The I-9 requirements and the E-Verify requirements are two completely different programs, two completely different requirements. So you want to make sure that you are still doing your I-9s. So E-Verify does not replace you doing your I-9s. Please keep that in mind. I personally suspect that we are going to see an uptick in ICE raids at work sites in the state of Florida as a result of Senate Bill 1718. I think we're going to see more ICE raids. They're going to be looking at the I-9s. I think, I just think that's what's going to happen. So if you are not quite sure about your I-9s, you need some assistance with your I-9s, feel free to reach out to our office. We are happy to help. As well with the I-9s specifically. This is I-9, so this is now we're moving out of the state of Florida. This is nationwide. The next thing I want to talk about are our I-9s in general. So during COVID, banning in March of 2020, it was stated that we could, as employers, review I-9s remotely because of social distancing, because of health, all of that. That is coming to a swift close. So if you have not reviewed all of the I-9s and determined which ones were reviewed remotely, now is the time to do so, because you now need to see all of those original documents in person. If you are unsure how to do that, if you have a completely remote workforce now, and you're just not sure how to make that happen, please reach out to our office. We're more than happy to get you a consultation so that we can kind of walk you through some processes and procedures that you may want to put in place so that you are compliant with your I-9s. So again, you can feel free to reach out to us to 954-903-1337. The last thing I want to talk to you all about is another national interest waiver tip. So as we know, I've been talking about national interest waivers for a little bit now. National interest waiver is one of the EB2 green card categories. EB2 category in general says that you must have a master's degree or higher in order to qualify for that category. And a national interest waiver is a subcategory of the EB2. So in addition to a master's degree, we need to show that the job that you want to have, or the job that you're being sponsored for, or the job that you are self-sponsoring, because we know that you can self-sponsor your national interest waiver application, must have both substantial merit and national importance. So essentially, you have the ability in your job to positively impact the nation. And two, that you as an individual are well positioned to advance your proposed endeavor, meaning once you get the green card, can you do this? Do you have the background to make this happen? Do you have the educational background? Do you have the experience background? So the Immigration Service wants to see that you have the background, that you have a plan. And the third requirement is that on balance, it would be beneficial to the United States to waive the usual green card requirements, those requirements being a job offer, so being sponsored by a specific employer, as well having that employer advertise for the position and look for a qualified U.S. worker as part of the labor certification application process. So that is the national interest waiver in a nutshell. So my tip is that the national interest waiver green card is not limited to only those individuals in STEM fields, STEM being science, technology, engineering, and math. If you are an entrepreneur, you can absolutely qualify for a national interest waiver. So please don't think that national interest waiver is only for those individuals who have STEM careers, because that is just simply not the case. So that is all I have for you all this beautiful Monday morning. Have a wonderful Monday morning and a great rest of your week. Enjoy your 4th of July tomorrow. If you have any questions about immigration, how you can hire someone that you are looking to hire, how you can support and sponsor that person through a green card, or if you're interested in self-sponsoring your employment-based green card, please reach out to us at 954-903-1337. Have a wonderful rest of your Monday and a great July 4th. Bye, everybody.